Good morning, everyone. This is Mary Matheron. I'm the Senior Assistant Dean for Development and Alumni Relations, and I'm so delighted that you could join us today for an extremely interesting topic, and that is exploring the legacy of Justice Ruth Bader Ginsburg. We are very, very fortunate today to have two wonderful panelists with us, our own graduate, Judge Marsha Berzon, class of 73, and Professor Amanda Tyler. And without further ado, I'm going to pass this on to Professor Tyler to begin the conversation.
Hi, everyone, and let me say what a great honor it is to be here with all of you, and what a special treat it is to be here with the judge. As you will hear, she had a front row seat to some very special parts of the building of the legacy of Justice Ruth Bader Ginsburg. Personally, also, it's just always a treat to be able to be with you, Judge, and talk with you. We are especially thrilled, both of us, to have had an early preview of the attendee list, and we both saw many friendly names on there. In my case, many former students, so I'm especially thrilled to have seen that, and I hope all of you are well. So without further ado, let's get right into it. What did I mean when I said she had a front row seat to the beginning of the legacy of Ruth Bader Ginsburg? What I mean is that Judge Berzon was clerking at the Supreme Court during the 1974, I got ahead of myself there, 1974 term. And that meant that Justice Ginsburg, then just Advocate Ginsburg, had not one but two of the 6 cases that she argued before the Supreme Court argued that term. One of those was Weinberger versus Weisenfeld. And that is a case that I will share with all of you. Justice Ginsburg told me was her favorite case that she argued. It was a case that was very special to her. So I'll share a little bit about it, and then I want to turn it over and hear what it was like to be at the Supreme Court that term, to work on that case, and to really be at the court during what was, I think it's fair to say, a pivotal moment or a pivotal period in the history of the development and movement for gender equality in this country. So the Weisenfeld case involved a widower named Stephen Weisenfeld, whose wife had died in childbirth. Maybe many of you know this story. He wanted to stay home with his son until his son went to school. He did not want to work, and so he went to collect benefits from the Social Security office on the basis that his wife had been a teacher and she had paid into the system, and he hoped to receive the benefits and piece together enough money to stay home for a few years with his infant son. He was told when he went to collect that those benefits were only available to women, that a man could not collect on them. And so he wrote a letter to his local newspaper in which he said, among other things, "I wonder if Gloria Steinem knows about this." Well, I never was able to identify for sure whether she saw that letter to the editor, but it did come to the attention of one Ruth Bader Ginsburg, who took on the case from the district court all the way to the Supreme Court. And she told Stephen Weisenfeld from the beginning, we're going to wind up in the Supreme Court. So just hang in there with me. We're going to be at this for a while. Now, Judge, you were there. You were clerking for Justice Brennan at the time. And it must have been amazing to be there during this period. You also, I know you told me, worked on this case. Can you tell us a little bit about that experience and what it was like to be there and what your role was and just really all about it?
Thank you, Amanda, and thank you all for watching this. I did notice that there were a few members of the class of 73, as well as some friends from various other classes. So hello to everybody. Yes, I was a law clerk for Justice Brennan in 1974-75. I was the first woman law clerk for Justice Brennan, and that's another story that we won't tell today. There were 4 women clerking that year. we were 4 of the first 11 women who had ever clerked on the Supreme Court. So we were the first, not even a minimum mass, but a minimum mass. One of them, Karen Hasty Williams, died just a few weeks ago, and the other 2 were Penny Clark and Karen Moore. Karen, whom I spoke to today because I wanted to find out whether she was a Sixth Circuit judge, as many of you probably know. So what I discovered about the input of the women on the court to the Weisenfeld case is, interestingly, if you go online, and I just found this out a few weeks ago, Justice Powell's papers are, or a lot of them are online. So you can look by case and you can read the internal files, which was fascinating. And one of the things I learned was that Penny Clark wrote, after a male clerk had told him that this should be granted and summarily reversed, based on a case from the previous term, wrote a memo disagreeing with that and supporting an affirmance, which was Justice Ginsburg's position. I do not actually remember the argument as such, although I've read the transcript. That may be because we didn't that often go to see arguments. So I don't know whether I actually saw the argument, but I certainly read the briefs carefully. And I was in some contact with her later about the case, which I will describe after a bit. So Justice Brennan, for the first time ever, and only time that year, as far as I know, asked me to write a memo on the case, which he told me he shared with the other justices before the conference. I didn't see it in Justice Powell's paper, so I don't know whether it was actually literally shared. But Justice Powell's notes about what Justice Brennan said at the conference reflected the memo, which went somewhat more deeply into the structure of the Social Security Act. And then the brief itself actually did. The case, of course, was an interesting one in the sense that one could argue that the woman was being discriminated against on the basis of sex, and Justice Ginsburg argued that, or that the man was being discriminated against on the basis of sex because he wasn't able to be paid to stay home with his child and make the choice, and she argued that, or that the child was being discriminated against on the basis of sex because he had only one parent who was a male and he was not able to get Social Security benefits to enable that parent to stay home with him, which was actually the position that was most attractive to Justice Rehnquist. But as it turned out, the case was 8-0 with 3 opinions. It could be the only sex discrimination case that I know of that was actually 8-0, although with a somewhat fractured opinion. And when Justice Ginsburg was confirmed to the court, I wrote her a note and mentioned that I'd been involved as a law clerk with Weisenfeld, and she wrote back to me and told me, well, you know, Jason Weisenfeld, that's the child, is now a lawyer. And either then or later, and I think this is sort of indicative of her affection for the case is indicative of her affection for, sort of human plights, which this certainly was. But she also told me, and Amanda said she'd never heard this, but I know for sure she told me this, that either in that letter or another time, that whenever she saw Justice Rehnquist in the years before she got in the court, he'd say to her, oh, and how's the baby? The baby being Jason Weisenfeld. So that is a short version of what I remember about Justice Brennan. One other piece that's probably worth mentioning is that this was 2 terms after Frontiero versus Richardson, which Justice Ginsburg also argued as amicus, I believe. And that was a case about whether women in the military got full benefits for their spouses as dependents, or only if they could prove dependency. And in that case, Justice Brennan wrote an opinion completely adopting Justice Ginsburg's argument that sex should be a suspect classification, but he only got 4 votes for that position. So when we were working on the Weisenfeld opinion, we needed to skirt the level of scrutiny issue, and we did so. Thanks, Amanda. So I am now going to ask you something, which is what was it like to work as a law clerk for Ruth Ginsburg, and what did she teach you as her law clerk?
So, it's really interesting to me. First, I have to hit pause and say, I can't imagine being one of only 4 women at the Supreme Court among the group of law clerks. And I also can't imagine being one of the first 10, 11. That's really amazing. We certainly weren't 50-50 in terms of numbers when I clerked in 1999 to 2000, but there were quite a large number of us by comparison to 4. And in my chambers, it was 2 and 2. Justice Ginsburg typically hired 2 women and 2 men almost every term. Working for her was, as you can imagine, it was a dream. And I wonder if you had the same experience. You surely were reading Brennan's opinions in school. And I was reading about Justice Ginsburg as an advocate, and these cases we're discussing, Frontiero, Weisenfeld, and the others that she had argued. And then VMI came down while I was in school. And here I was shortly thereafter interviewing to clerk for her. And the first thing I would say at the outset is this was someone who, before I ever met her, was a personal hero of mine. So to be able to have the opportunity to work for her and with her was just a constant stream of pinching yourself moments, because it was so special. In terms of getting to know her and working with her, she was meticulous to the extreme. She was incredibly detail-oriented, an exceptionally hard worker, and many people have talked about this. She could really burn the midnight oil. She would often stay up most of the night working, and then if there wasn't court, she might sleep in. If there was court, a few of her law clerks and I were joking about this weekend. You'd have to really make sure that Marty got her up in time, or she'd sleep through arguments. But she expected a great deal of her clerks, in the sense that if she was going to work that hard, if she was going to be that careful and that meticulous, she expected the same care and work ethic from us. And frankly, it was not hard to try to deliver that, because we were trying to live up to the example that she set. I think it would have been different if she had been lazy, for example, but she worked so hard that you really wanted to kind of meet her there and impress her. And so that was what we did. I mean, it was a constant labor of love to try and win over her praise. And she would really kind of push you and try to make you be your best. So for example, I would turn in, I don't know if you do this with your law clerks, but I would turn in a draft opinion and it would come back completely covered in ink. I mean, you couldn't even see the type print on the page. And we would go back and forth and back and forth. And sometimes it was dozens of times, especially if it was a particularly important opinion or lengthy opinion, then there would be multiple rounds. And you just kept striving, kept working, kept going back and forth. And at the end, you would at one point finally get back a clean copy that would say, good job, this just right actually was the phrase she always wrote. And so it was a constant endeavor to get just right back. But one thing in particular I will note is that she sat down with you every time, and she would go through the changes that she was suggesting and explain why. And this is somebody who did not have a lot of free time on her hands, to put it mildly, but she looked at the clerkship experience as one of not just extracting work from us, but also teaching us. And I'm forever grateful for that, because I learned so much about good writing, about legal arguments, about legal reasoning, about how to think about the Constitution, about how to think about the role of the courts, all in this year. And then, if I can just say a few words about the personal side, being able to watch her and spend time with her, and particularly to spend time with her and her husband, Marty, who was alive at the time and was a truly extraordinary human being in his own right, I really learned a lot about how to live a good and happy life. They had an amazing marriage. They lifted one another up and celebrated each other and also gave each other a very hard time. And they had robust interests outside of the law, opera, cooking, travel, etc. And they were also both just incredibly kind and generous people. And so that was also a really special component to the clerkship. And I can say more, but I've been talking for a while, so maybe I'll pitch it back to you if I can. She and I, as some people in the audience may know, worked together in the last year of her life on a book called Justice, Justice, Thou Shalt Pursue. It's over my shoulder. A life's work fighting for a more perfect union. The book comes out of a visit that she made to UC Berkeley in 2019 when I interviewed her about her life. And that interview is the core of the book. During that interview, I asked her about what it was like having been a part of a generation where there were not huge numbers of women law students. Now, what was it like for her to see at Berkeley Law and so many other law schools that the student bodies are sometimes as high as they are at UC Berkeley, as 60% women? And I'll put aside her answer. I'd love to hear from you, Judge, about what your experience was in law school, what the percentages were of women, and what it's like for you now to look so many years later and see that we have so many women lawyers coming into the profession.
So I always think of myself as being sort of a generation, well, it was really only about 15 years, or maybe closer to 20, after Justice Ginsburg, and after the two other people who I always think of as the beginners of feminist law and women in the law advocacy, Herma Kay at Berkeley and Barbara Babcock at Stanford. So they were for me, the trinity of models. When I started at law school in 1970, Herma was teaching at the law school, and Barbara Babcock was teaching at Stanford, and Ruth was teaching, I guess, at Columbia. My class at what we call Balt Hall, and I have a hard time not calling Balt Hall, was approximately 20% women. I've learned recently that the fact that it was even 20% women was the result of a fair amount of agitation by the 2 or 3 classes of women before us, and that is shortly as 2 classes before us, it was more like 10% women. But one interesting sideline about this is that at one of our class of 73 reunions, I took it on myself to go asking various people what they thought the percentage of women in the class was. The men uniformly said 50%. The women uniformly said 10%. Which is some indication of the fact that women felt marginalized and men felt overwhelmed or something. I mean, as to my reaction to the current situation, I guess strangely, the difference between 20% and 60% is less, I think you feel less on the ground than the difference between what Justice Ginsburg encountered at Harvard, which was like 10 women in the class or something, or even when my husband graduated in 68 at Harvard, there were something like 25 women in a class of over 500. Once you had 20%, the presence was palpable, not marginal, and diverse in various ways. I mean, the women were not cookie cutter at all. So I didn't feel at the time, and it could easily have been because of Herma's presence keeping everybody on their toes, that the otherwise almost all male professors, there was one other woman, were patronizing or excluding women in any way that I was able to perceive. One other interesting thing about the years that I was at law school was that the women in the law class didn't exist when I got to law school. There was a women's group, Baltimore Women's Association, and it agitated so that by the third year, there was a women in the law class offered. And I believe the materials were ones that were starting to be put together by Justice Ginsburg and Professor Kay that became their case book about a year and a half or 2 years later. But the class was not taught by Herma Kay in the spring of '73. It was taught by a woman whose name, unfortunately, I haven't been able to dig out, who was, as I recall, the Dean of Admissions. And the problem was that Herma either was on sabbatical or was her teaching load was full, and she just couldn't teach it. So some other person who was very good but wasn't actually a law professor was the first professor of women in the law at Berkeley. Somebody should dig out her name and memorialize it. So that is what a short version of some of the things I remember about women at the law school.
Well, and it's hard to talk about Berkeley law, whether it's 5 years ago or when you were in school, without talking about Herma, especially if we're also here talking about RBG, because she and RBG, as you said, worked together on that very first casebook on gender discrimination in the law. They had a third co-author named Kenneth Davidson. The casebook published in 1974. And they're writing it together. Both of them are litigating cases and they're writing that law in real time while they're also writing the book and creating the field. But it's fascinating to me that Herma didn't teach that first iteration. I wonder if maybe she was too busy writing the book.
Might have been that, or she might even have been a sabbatical. I don't remember.
Maybe. Well, the reason that Justice Ginsburg came to UC Berkeley in 2019 was to honor Herma Hill Kay. And I'm sure many of the people who are joining us have very fond memories of Professor then Dean Kay. I personally was so privileged to be able to overlap with her on the faculty for, I think it was 5 or 6 years after I came before we lost her. And Professor Pam Samuelson and her husband endowed the Herma Hill Kay Memorial Lecture. And that's why Justice Ginsburg came to Berkeley in 2019. To give the very first lecture, although we made it, as I said, a conversation between the two of us. A little thing that a lot of people may not know is that she was, or may not remember, is that she was supposed to come in January of 2019, but Justice Ginsburg in December of 2018 broke a rib, and as a result, they discovered that she had actually lung cancer. And so she had to have surgery and treatment for that. And I kept calling her saying, we really need to postpone this. You can't travel, surely, in a month or two. And she was very resistant. And I asked her why. And she said, it is just so important to me, she said, to honor Herma. She was my best and dearest working colleague for so long and such a treasured friend. And so she did eventually, under doctor's orders, relent and say, we have to postpone, but it was, I think, the very first thing that she rescheduled when she started booking events again as she got better. And it was just so important for her to come and honor Herma at Berkeley. And another story that a lot of people may not know about her connection to Herma is how our book came into being. It's connected, as you can see over my shoulder, to Herma's book called Paving the Way, which is a book that tells the story of the first American women law professors to join the academy, and tells the stories of how hard it was for all of them to do that. These are the women who came before Irma Hill Kay and Ruth Bader Ginsburg. And Justice Ginsburg had written the introduction for Irma's book in 2015. Yet by the time Irma passed away in 2017, several publishers had turned it down. They did not want to publish the book. We knew that in 2019 when Justice Ginsburg came to UC Berkeley. And we also knew that the University of California Press was reconsidering publishing it, having turned it down before. And so we got the idea that maybe we could put together our own book and offer it exclusively to UC Press, contingent on the press agreeing to publish it alongside Irma's book. And the press, unsurprisingly, happily went for it. And that's why we have the two books together. We also made a point of including some of Irma's testimony at Justice Ginsburg's confirmation hearing in our book. So each of them has pages of their own writings and words in one another's book. And I really like that. I think that's really special. But the reason I share the story is because it connects back to the question you asked me before, which is to talk a little bit about what Justice Ginsburg taught me. And one of the biggest lessons that she taught me was how to use your position to lift up others. And I think this is a really beautiful story of how she used her position to make sure that Irma's final work was published, both to honor Irma, but also importantly to honor the stories of all those women who came before them. And that was really important to her. Now, I've been talking for quite a while here. You had some really special memories of Justice Ginsburg, and one in particular that you shared with me that I think also sheds light a little bit on aspects of her personality that maybe not everybody understood or maybe not everybody knew about. So I'm wondering maybe if you can tell us a little bit about the Mira Bradwell arguments.
There were actually two Mira Bradwell reconstructions or that Justice Ginsburg was in. The first that I know of. The first was I happened to be in Washington one evening, and some friends of mine invited me to come along to Georgetown Law School, where there was a portrayal of the case of Bradwell versus Illinois. Bradwell versus Illinois was the case in which a woman, Mira Bradwell, who wanted to be a lawyer, was told by the state of Illinois and by its courts that she, as a woman, was not eligible to be a lawyer. And the case was taken to the Supreme Court, which gave it fairly short shrift and announced that women were not so composed as to be able to practice law. And therefore, she lost. At the Georgetown portrayal, I believe Justice Ginsburg played Mira Bradwell arguing for herself, but I'm not sure. In any event, the main thing that I do remember is that she was incredibly funny. And I had never really thought of her as being a particularly funny person, but this was really, she just had interesting, funny lines all along and very perceptive ones as well. So some years later, I was on the Ninth Circuit Conference Executive Board that we used to have, we have not since COVID, have a conference every summer for all Ninth Circuit judges, district court, magistrate judge, and so on, and a lot of lawyers as well. And it's something of an extravaganza, and I was responsible for putting together a program, so I decided we should have a program called 50 Years After Reed versus Reed, which was the first of the modern sex discrimination cases in the court. I had forgotten that Justice Ginsburg's name was actually on the brief in that case. I don't believe she argued it. So I invited her to come and to do two things. One was to do a reprise of the Bradwell versus Illinois demonstration, and the other was to be on a panel about what women's law jurisprudence since, including Reed versus Reed and forward. The second was a little bit of a debacle in the sense that by the time the panel got to Justice Ginsburg, we were kind of out of time. I kept writing notes to the other panelists, stop. But in fact, Justice Ginsburg got about, 5 minutes out of it. And she was extremely gracious about it, but I was extremely embarrassed. But the Mira, the Bradwell versus Illinois portrayal was just as good as the first time. And we had really cool costumes. Right around the corner from the courthouse was, and maybe still is, the ACT costume store. You could go there and you could get great costumes, and we got costumes. And I had a big hat when I talked. And this time, I believe she played one of the justices. And again, she was just incredibly funny and really had everybody laughing out loud. And to me, that was just an important aspect of her character that I had never seen directly, because she tended to speak very softly and very modestly when you spoke to her directly. I'm sure Amanda can talk to us more directly, and therefore, and not a joke cracker. But when she was up in this big group, she was. The other sort of vaguely connected thing is that an aspect, not so much of her character, but of her legacy, that I think is extremely important, is that for whatever reason, she has become an icon for young girls. The RBG phenomenon, not Hillary Clinton, not Kamala Harris, not any other. And I've seen this through my granddaughters and granddaughters of friends. One of the granddaughters of one of my friends has Justice Ginsburg paraphernalia all over the place, and she has her collars reproduced and so on. And my granddaughters, I have 3 granddaughters, but the 8 and 10-year-old, both. I remember in the summer of 2020 when Justice Ginsburg died, the almost 10-year-old then called me up and said, Grandma, this has been a terrible year, but now that Justice RBG has died, we know it's the worst year ever. And my other granddaughter wrote an essay about her in 2nd grade, and I think that's an incredibly important role, because these sort of middle grade girls really didn't have another feminine or woman model, and she became absolutely critical to their sort of self-image. So, Amanda, the book that you and she put together had a bunch of cases appended, either the cases themselves or the arguments. And why did she choose them when she chose? Which were they, and why did she choose them, do you think?
Yeah, so I'm going to hit pause for 2 reasons before I answer your question. The first is to say, along the lines of what you were saying, how many octogenarians are held on, in such high esteem by so many people? It's just extraordinary to me, your stories about your granddaughters. And also, I will say personally, what I saw when we went as law clerks to honor her after her passing, and we stood on the steps of the Supreme Court, and we stood vigil by her side while people came to pay their respects. There were a ton of children who came with their families dressed up like her. And in one case, let me see if I can find it, because I want to show the audience this picture. When I saw it, I did not see it in real time, but when I saw it after the fact, I insisted that we put it in the book, of this little girl dressed up like Supergirl saluting her. I just thought that is so special, and I think the justice would have loved it. So that's the first pause point I want to make. The second is just to reiterate to the audience that we jumped right in, and we are going to leave time for questions at the end. If people do have questions for either of us, please go ahead and put them in the Q&A, and we'll be happy to respond. Or maybe there's another way that they're doing it. I'm sure they've posted an announcement in the chat about that. Now, you asked me about the book, and I just want to begin by saying what an unbelievable privilege it was and how very special it was to get to work with her a second time for the better part of a year on this project, 20 years after having clerked for her. And, before I get to the cases, I'll just share a little vignette, which is super embarrassing, but also super funny. So I'm willing to check my pride at the door to entertain an audience. She would ask for pages over the summer. And this is the summer of 2020, that year, that terrible year. And she would be in the hospital and say, just like when I clerked for her, when she had her first bout with cancer, I want work, keep me busy. I want to keep my mind off of what's going on. And so I would send her pages from the book to mark up. And they would come back as marked up as those opinions I was describing 20 years ago, which is a little embarrassing because I think it shows that maybe I hadn't quite made as much progress as I thought I had. But the most embarrassing part of all of this is that because she was in the hospital, I would send pages with a cover email to her assistants who would print out everything. So we were doing everything old school. She was marking up hard copy. And she even found typos in my emails and edited those and pointed those out. So I share that because it's embarrassing, it's funny, but it also shows that even at the very end of her life, she was just as meticulous as ever. Now, when we were choosing what cases to include, we decided to include in the book, and I should say we also included her final speeches, including a really, really spectacular speech where she talks about her family story. It's a naturalization speech for new citizens. And she talks about her life and her love of country. And it's the last major piece in the book. But we also included vignettes from her time as an advocate. And that's how I came to talk to her about what her favorite cases were from that period, including Weisenfeld. And Frontiero, I should say. And then included her very favorite opinions. Now, she wrote over 1,100 opinions in her time as a judge. She was on the DC Circuit from 1980 to 1993, and then, of course, on the Supreme Court from 1993 to 2020. So that's a pretty lengthy run there as a judge, 1,100 opinions, hundreds on the Supreme Court, and she chose 4. And she said, these are my very favorite. Now, they were VMI and 3 dissents. And the dissents are an interesting choice. VMI was her first really big majority opinion. She got Chief Justice Rehnquist's vote there. He didn't join the opinion, but he joined the outcome of the court holding that the state of Virginia could not keep the doors of the Virginia Military Institute closed to female cadets who wanted to attend. It was a very special opinion to her for a lot of reasons. I can come back to that and talk about it, not the least of which was it was a capstone really to all those cases like Weisenfeld that she argued in the 70s, only now she's writing for the court, citing those victories as precedent. But then 3 dissents. So Shelby County, Ledbetter, and Hobby Lobby. And I think she chose those for several reasons. One, she did not like to lose. I cannot stress that enough. She really hated to lose. 2, in those cases, I think she thought the court was really off the rails. And she said in her Shelby County bench statement, which we've also included in the book, that the court had not just erred, they had erred egregiously, which for RBG, those were pretty much fighting words. She was really incensed about what the court had done in Shelby County in gutting portions of the Voting Rights Act, specifically the pre-clearance provisions in the Voting Rights Act. And then in Ledbetter and in Hobby Lobby, you have cases that are about gender equality. In Ledbetter, gender-based pay discrimination, in that case, ongoing cumulative pay discrimination. And in Hobby Lobby, you have a case about reproductive freedom and the viability of Congress's mandate that employers provide contraception. That's a case in which the majority expanded the employer exception to the mandate and allowed for-profit employers who claimed a religious objection to get around and not comply with the contraception mandate. I think in every one of the cases, She also chose them because she considered these issues that were still very prominent, very much in play, and very much in need of continued advocacy and attention and work. And when she was thinking and working on this book, obviously she knew she was at the end of her life. And we dedicated the book to all those who worked to make ours a more perfect union. And I think the idea here was for her to leave something of a roadmap to people to think about what she would like to see us still working on today in her stead. You know, if I go back to VMI, I think it connects to this in some respects because there were other reasons why it was special to her, not just that she got to cite the precedents of the victories that she had won through all that work in the 1970s. It was also special to her because Justice O'Connor had been offered the opinion and said, no, Justice Ginsburg should have it. And she told me, when she told me that story last summer, that she always thought of Justice O'Connor like a big sister, and that she loved her that way and felt very grateful to her for all that Justice O'Connor had done for her when she came on the court. And this is just one of many stories she used to tell in that regard. The other reason why it was so special, and I think this connects back to the inclusion of so many dissents in the book, is that she had litigated a case in the 1970s called Wertheimer. And that case was a challenge to segregated high schools for boys and girls who were high achieving in the Philadelphia area. And this is the 1970s. These high schools were not equal. The boys' high school had better facilities, better faculty, a wider array of classes, particularly in science and math. And the girls' high school was really quite inferior. And so a group of girls brought a class action saying, we want to either have an equal high school, or we really just in immediate time, we want to go to the boys' high school. And the district court actually agreed with them, but the Third Circuit reversed on appeal. And then the case went to the Supreme Court. At that point, the ACLU and Justice Ginsburg got involved, and they wrote the opening brief. But there was a huge difference of opinion between the two groups, the original local counsel who had started the case and the ACLU team led by Justice Ginsburg, as to what the right approach to the case should be. Local counsel wanted to raise an argument that was more along the lines of a Brown versus Board of Education argument, that inferior schools made the girls who were attending them feel more inferior, whereas Justice Ginsburg and her team really wanted to continue with the same arguments that they'd been winning on in Weisenfeld and Frontiero and in the other cases that they'd been litigating up until that point. Well, because of that disagreement, local counsel pushed the ACLU off the case and wrote the reply brief and argued the case herself. The Supreme Court, you made mention earlier, Judge, to 8 votes. How many 8-vote cases do we have in these? Well, this was another one, and the court split 4-4, which means, of course, that the lower court decision was affirmed and the separate high schools were upheld. And Justice Ginsburg liked to talk about how VMI 20 years later allows her finally to right that wrong and effectively to overrule Wertheimer now under her pen. And I think that's really important because she often thought about and talked about taking the long view to progress and how important that was. And again, I think that's why she wanted to include so many dissents, because she was always hopeful, ever hopeful, realistic or not, about her dissents and that they could eventually become law. And I think the lessons of, or some of the lessons of her life, including the Wertheimer case, really helped her have that optimism and to believe that if you just keep doing the work, eventually you may prevail. Now I'm looking to see we're at quarter of whether we have any questions. And we do have one question, and we can certainly field more if people would like to chime in on the Q&A with questions. One that we have is whether Justice Ginsburg and whether her legacy is at all shaped by her decision not to retire sooner. Now, I don't know, Judge, if you would like to take that, or if you would I'm going to guess that you're going to want me to take that one.
Why don't you start? I, without commenting on the question whether she should have retired sooner, which I gather is the implicit question here, I do note in terms of what I said earlier that for whatever reason, this sort of iconographic view of RBG was in the last years of her life. It essentially, certainly in the last 10 years and maybe even the last 5, that this whole notorious RBG thing took off, and there were movies and there were books and so on. So in that regard, by staying on, she did create, I'm sure entirely unintentionally, this aura that continues with regard to her both importance and model existence as a model for women in general. I'm sure that's not at all why she did it, but it was the kind of unintended consequence.
Yeah, it's interesting that, it's really with the Shelby County descent that she takes on this persona. That's what leads someone to give her the moniker, the notorious RBG. And it's at that point that she becomes this larger than life role model, really, for so many people. It's interesting to those of us who clerked for her, we like to say pre-notorious. We're sort of divided into these categories, pre and post-notorious. We always knew she was a rock star, but the rest of the world didn't seem to know. But what's interesting to us is that we thought she was so shy and reserved. And so when she became this larger than life notorious RBG, it was amusing to us because she's really, frankly, the last person in the world we would have expected that to sort of happen to. But to speak to the question, I think it will be impossible for people to write, particularly with the way things are going right now with the Supreme Court, impossible for people to write about her legacy without commenting on when she, left the court and what the impact was. People have obviously criticized her for not leaving the court earlier. What I can say from my vantage is that she loved that job. And the reason I think she loved the job most of all was because she loved being a public servant. She loved this country and she loved it deeply and passionately. And that really comes through when you hear her voice, for example, in the naturalization speech that we included at the end of the book, because there she talks about how this country gave her family refuge when they were fleeing persecution in Europe. And she was only first generation American on one side, and very, very proud that in a country like this, someone with her background could wind up on the Supreme Court. That is something that is really special about this country. And I think she had this profound love of country that really drove her. And frankly, I think made it hard for her to walk away from the life of a public servant and walk away from the ability to give everything she had to this country that she loves so much. I see we have lots of other questions coming in now. This is a good one. If I can ask you, Judge, and it's written by a former student of mine. For many law students and younger lawyers, we often idolize the justice in her position on the court. But what lessons and examples do you think should be celebrated from the early part of her career? Do you want to take a go at that one?
Yes. One thing that, or the main thing that becomes clear when you go back, as I had the opportunity to do in the past few days, her early briefs and the opinions from her early briefs, was that she had a clear vision from the outset of what it was she was trying to convey. She understood, that is, she had a distinctly egalitarian view of the sex discrimination issue, meaning that it affected both men and women adversely, that is, the traditional divisions. and that it was legitimate to bring cases on behalf of both men or women, or as in Weisenfeld, both and the child. And there was some pushback on that at the time and later, as I'll describe in a minute, on the theory that men weren't actually being disadvantaged, but her vision was that they were being disadvantaged because they were being disadvantaged, as was Mr. Weisenfeld with regard to his parenting role, and also choices about how people were to live their lives as a family and who was to be the main wage earner and so on. And she stuck to that vision and played it out all the way through, for example, to be, in my opinion. And as I say, it was, and I came into the kind of women's rights litigation world after 75. And I remember a meeting in 1977, probably, right after the Supreme Court opinion in General Electric versus Gilbert, which held that pregnancy discrimination is not sex discrimination under Title VII. And there was a meeting that I attended in Philadelphia of a bunch of women's rights advocates as to a legislative fix on that. And Ruth Ginsburg was there. And Ruth Ginsburg was, definitely the wise resource. She was she was 15 or 20 years older than most of the rest of us, and had been the progenitor of the whole theory on which she had litigated for so many years. She was just about, I think she wasn't yet nominated to the DC circuit, but it was somewhat in the works. So she wasn't all that vocal at that meeting, but she was there, and certainly people would turn to her every so often. And this dispute broke out, which continued for years, about whether the women's rights advocates should be advocating for equal rights, as Justice Ginsburg insisted was the right approach, or rather for some recognizing the special disadvantages of women for particular benefits, for example, for women that were not available to men. And I remember that, for example, the Women's Bureau at the Department of Labor wanted a plan which would have provided for maternity benefits for women, whether or not there were similar benefits for men. And Ruth Ginsburg, was really the living embodiment of the position that kind of approach was both unwise and philosophically incorrect. And unwise because she understood that she was arguing to a Supreme Court and to courts of appeals that were just about all men, and that if one wanted to explain to them the inequity of the current assumptions about family life and roles, one needed to do so in a way that would not create a backlash. And so for me, I guess the lesson from all this is that she worked out a legal theory, she believed in it deeply, and she persisted in it throughout her career as an advocate and as a judge, and wasn't deterred by detractors from her own ranks. So
I think that's a phenomenal answer. I'm not sure what I could add, but if I were going to add one wrinkle, it would be building on the example you gave of the pregnancy, the Gilbert case and the Pregnancy Discrimination Act, which is, and this is something she wrote an op-ed, interestingly, about, and you and I've talked about this, that the New York Times published after 2 losses in the Supreme Court, in which the court, both as a constitutional matter and as an interpretation of Title VII, basically said pregnancy targeted laws they are not gender discriminatory. She and her colleague wrote an op-ed saying, guess what? Congress can amend Title VII and fix this. Congress did. You have the Pregnancy Discrimination Act, in which you played such a significant role. And later on, in one of those dissents I mentioned, Ledbetter, she uses that same tact and says, the majority here has misinterpreted Title VII. Congress can fix it. And Congress does very soon thereafter. This connects back to something she said when I interviewed her at Berkeley, which was, if you could achieve your objectives through legislation, often that was a preferable course to going to court. And so that's something else I would say to young lawyers who are passionate about certain causes. And I try to instill in my students when I'm teaching them, which is, even though I teach federal courts, and I very much teach and write about court-centric doctrines, we don't always necessarily want to be just fixated on the courts. Now we've got a few minutes left and a couple of questions, and I skipped over one from a judge who asks us, what qualities and traits did Justice Ginsburg seek in her law clerks? So I definitely want to answer that. And unfortunately, I'm not entirely sure, because I have to share with you all that she never hired anyone I recommended to her. I've had much better luck with other justices over the years in terms of placing law clerks. But what I do think, being serious in terms of coming back to my own experience and who I know she did hire over the years, I think she tried to hire people who were hardworking. And frankly, I think if you didn't have a strong work ethic, you wouldn't do well in that clerkship, because you wouldn't be able to keep up with the boss, frankly. I think she tried to hire people who also, as best as she could discern before she hired them, shared in her care for the effects of the law, which is to say, one thing that really struck me when I worked for her during the clerkship was how she would try to take this high-level abstract issue that was before the Supreme Court and really think through how it will trickle down to the everyday lived experiences of people. And you see this in her opinions. And so I think she tried to hire people who would bring either insights that would be helpful to that, or who would be willing and dedicated to doing the work to try to think through how issues were affected, how issues before the court affected the lives of real Americans. And so that's something that I think is a really important component to thinking about her legacy and how she thought about her role as a judge. And there are certain areas, we don't have time to go into them, where you can look and you can see that even over time she evolved to better understand certain areas as she learned more about them. And I think she tried to hire clerks to help her in that regard. Let me see, we're getting down to time. We have another question that asks, would Justice Ginsburg join Dean Chemerinsky in calling for an expanded number of justices on the Supreme Court? For that, I can't speak for her in the sense that I don't know what she would say today. I can tell you that before her passing, she was resistant to the idea of expanding the court. She was very much an institutionalist in the sense that even up until the end, she very much believed in the institution in its current form. Whether she would say that today, I can't say, I can't predict. But we live in interesting times. I certainly did not think that some of the abstract things I teach in my Supreme Court seminar about various suggestions for court reconstruction and expansion or term limits would become such prominent fodder for public discussion. So it's an interesting time in which we live. We have one more question, and then I'll invite you, Judge, to maybe share some final parting thoughts. Will you make your book and Hermas available as a package at the upcoming virtual reunion? Oh, we've got another question that just came in that I'll answer as well. I love this idea. I will look into whether we can make a package of the books available to alumni. And I will be sure to let the Alumni Association get word out about that. Another final question we're asked is whether a recording of my interview of Justice Ginsburg in 2019 is available. It is widely available. Just Google Ruth Bader Ginsburg, UC Berkeley 2019, and you should be able to find a video of the interview. It is also the audio of that, as well as original audio from her Supreme Court arguments, including in Weisenfeld, and her bench announcements of the opinions that we include in the book are all going to be part of the audiobook that is coming out of our book with Audible, actually just in a few weeks. So I've had a great privilege being with all of you here today, and especially being with the judge. And I just want to thank you, Judge, for spending this time with us. Do you have any parting thoughts you want to share?
My parting thought is that it was really interesting to hear your reflections, and I'm so glad I was able to be part of this conversation. And as I reflect, it's so apparent to me that the women of my generation owe so much to Ruth Ginsburg and to at least the two other colleagues that I mentioned, and a few other women. There weren't a lot who were the champions of the beginning of thinking about how to use legal processes, both litigation and legislation, to change the lives of women in this country. And they were completely innovative, courageous, and Justice Ginsburg was certainly the litigation leader of them. So we owe her an enormous amount for that reason, as well as for all her many years in the court.
Well, thank you, Judge Berzon and Professor Tyler, for sharing such special personal insights on Justice Ruth Bader Ginsburg. My name is Yuri Kapkan. I'm Berkeley Law class of 2001. I sit on the board of the Berkeley Law Alumni Association and head up the LA Alumni Chapter. As many of you know, we've had some very engaging talks over the years, in person pre-COVID, and on this platform more recently, perhaps few more engaging than this one. I do truly miss seeing many of you in person, but I hope we can continue to stay in touch during these times. And I'll note for this particular event, we had hundreds of our alumni register spanning nearly 70 years of class graduation years, from the class of 1952 through the class of 2021. I really love that kind of engagement. As a reminder, we have our virtual alumni reunion coming up September 23rd through 25th. I encourage all of you to sign up for that. And with that, thank you again. Thank you, everyone. Take care and stay safe.
Thank you so much.
Thank you.